Hi, everyone. This is Matt with ESI Survival Guide. We are an online resource designed to help legal professionals navigate the electronic wilderness. And I could not be more thrilled today to have our guest. Actually, in the spirit of Thanksgiving, I should say that I could not be more thankful to have our guest, Ariana Tadler, joining us today. Hi, Ariana. How are you?
I'm great, Matt. How are you?
I am doing fantastic. And let me first start off by providing the disclaimer. You all know I had to do it. So the views and opinions that are expressed by us today are only ours, not those of our respective organizations, our friends, our family, or anyone else. And nothing on this podcast is to be construed as legal advice. So if you have a specific set of facts you're trying to deal with, consult your own attorney. There's also some legal language that is on the website ESI Survival Guide that you can reference. And I would like to invite you, if you're interested in the intersection of law and technology, please feel free to subscribe to the channel. We're always coming out with new content, even though I was on a hiatus for a little bit. You can hit the notification bell to make sure you're aware of when new videos come out. And if you do like this video, feel free to hit the like button or send us a comment, share your opinions, your questions, your views, because we definitely want this to be a dialogue. And with that, again, Ariana, thank you so much for being here. Ariana, I think you know the format a little bit. I usually like to present some background on my guests whenever I do this, but I literally was going through just the background I could find easily online, and it was like, it's like 5 pages of stuff, like not to blow you up, but so I figured rather than do an hour-long podcast of just narrating your amazing accomplishments, I would get into maybe some of the highlights. And I know one of the big highlights is that, and I believe this is for the 3rd year in a row, Chambers and Partners named you as the Band 1 top eDiscovery practitioner and the only practitioner from the plaintiff's bar that has that designation. Is that correct?
So it's more than 3 years. I actually don't know how many years it is now. I'm the only plaintiff's lawyer who's been identified as Band 1 by Chambers and Partners in the eDiscovery Global and USA Guide, which I take with great pride. I'm super honored, particularly when you see the other people who have been chosen and selected among the ranks, particularly Band 1. Those are people whom I've known for a very long time, some people who've been in the business far longer than I, and it just feels good. It feels very legitimizing and validating to be in that space and know that the work that I and my team are doing, because I don't get that accolade alone, but the work that I and my team are doing has really enabled us to continue to stay at the top of our game.
It's amazing. It's amazing. Huge accomplishment. You're definitely in the conversation for the GOAT, the eDiscovery GOAT. I could say that. When I was thinking about how to describe you, people call you a trailblazer. People have called you a virtuoso. I was listening to your podcast with Jim Batson from Omni Bridgeway, and he said, World Renown authority in eDiscovery. So I think I'm going to go with that as the primary moniker. But I feel weird introducing you because anybody who's in the data law or eDiscovery spaces, or just a practitioner in general, is aware of who you are, likely aware of who you are. And the cases you've worked on, not only do they span a significant amount of time. I mean, you were doing cases such as the IPO securities litigation with Judge Shinlin, even before a lot of this eDiscovery law that we talk about was even precedent. So you're actually trailblazing well before most practitioners in this space. And the number of cases and the names of the cases that you've been on, whether it's been as on the plaintiff steering committee or as class counsel, reads like a who's who. The Yahoo breach, the recent Marriott MDL, the Equifax breach is one. So it's extremely impressive. And also outside of your role as a legal practitioner, well, I guess let me first also say you were at Milberg, the mega plaintiffs firm for, was it 20 years?
Over 20 years.
Over 20 years. And you're a partner, trailblazing partner at Milberg as well. But even outside of that practitioner space, you've been an extremely prolific writer, speaker, content creator, lecturer in the eDiscovery area. and also serving in many leadership roles in this industry. Now you serve, correct me if I'm wrong, are you chair emeritus of Sedona Conference Working Group
Working
1?
Group 1, yes, I am chair emeritus for that. Yep.
Fantastic. And we had the pleasure of both serving on the Cardozo Data Law Initiative. So
Yes.
I had to work myself in there.
Absolutely. And that program was such an important program, for I think both of us at those times in our career. Ultimately, I became the executive director of the CDLI program there, and which is their data law initiative. I really didn't anticipate being invited to serve in that capacity, and ended up really learning so much more about, putting a program on, an actual academic program from the school side, right? So I always love being brought in as an adjunct or as just a speaker, because I spend a lot of time really trying to connect with the students or the people in the audience. But now it was being on the other side, saying, okay, let's really look at that content. And it wasn't just substantively the content, but how are we going to connect with the students, and how are we going to connect the students with the practitioners and the service providers, and give them this segue into finding a profession, a career, a job. And some of it was just purely mentoring, and some of it was really, professional advice, career advice, and giving people options that maybe they didn't even realize existed.
That's one of the things I really like about the eDiscovery industry growing into the larger data law industry, whether it's data privacy, security, and whatnot, is that it's created all these new avenues for individuals to really flex their talent, their expertise in the law. That traditional path of going from an associate to a law firm partner is now opened up in many different ways with this industry, with different avenues students can take in data law. So it's really, really interesting stuff.
Absolutely. And I think what we're seeing too is, there are times where I've spent time mentoring professionally people who are they've already started their career. Maybe they're at a law firm or they're at a service provider. And then when you're working with some of the great academic institutions that are out there, the law schools that have these types of programs, and often also some of the not-for-profits who have been really encouraging law students to be participatory, whether by scholarship or by some other means, looking at how, people from all of those arenas have all these additional opportunities and options now. When I went to law school, I was thinking, oh, I know the path, that I'm going to take. There are these steps, there's this hierarchy, you have to follow it. And then little did I know that I would have all of these different options and opportunities. And there are so many more that I've probably never thought about for myself. But when I do mentor somebody, I do say to them, hey, there's not a straight line for any of this. If we've learned nothing, we want to make sure that we're evolving, right? And that we are finding the joy factor. I'm hoping at some point we'll talk about the joy factor in our discussions together, because I think that's been a really important development for me over these last 20 months. But talking to people and saying, you don't have to think that you're only going to have 3 jobs in your entire career. I remember being told that when I was in school. If you're a good employee, if you do really well, you'll have 3 jobs, and that will be a career. And if you move around more than that, that's bad. That means that, you haven't really succeeded in any one place. And now, because I have adult children, because I've also mentored younger people who are now much more mature in their careers, you see that nothing has to be static. You can go to one place and you can succeed and do very nicely, and then you can change your mind, you can pivot, you can do something new. And that may be really critical for your fundamental well-being.
Right. And not only that too, and I like this idea of the joy factor. And there's a couple other things that I wanted to mention about your background, if you will, but
Sure.
it dovetails nicely because one of the things that's so unique about you and why I've always really looked to you as a mentor and someone that I've tried to follow in many regards in terms of my career, although I'm probably 50 decades behind in terms of talent and expertise, is that you found a way to really explore all these different avenues of this industry that you care about so much, whether it's the traditional practitioner side, now the academic side, the advisory and mentorship side, and even get into the nuts and bolts and the technology of what underlies all that we do in the eDiscovery space. You were a founding principal of Meta eDiscovery in 2015 with our very, very good friend, one of my favorite folks. Shout out to Paul McVoy. Can you explain a little bit? Was that designed as a labor of love? Was it something that you really needed to flex that muscle and you had the expertise to expand that? What was the impetus behind wanting to go from really what everybody would think would be the pinnacle of this industry, being a very well-regarded partner at a major firm doing eDiscovery, to actually kicking off a vendor service provider technology company?
So Paul McVoy, our CEO, gets all the credit. So Paul had joined me at my former firm, and we built together an eDiscovery practice group. I was already building a practice group of lawyers. So I'm a full service litigator. I litigate cases from the beginning to the end. I also have a passion for the eDiscovery arena, and so I enjoy that part. I still do all of the above now in terms of my legal practice. With respect to the eDiscovery practice, I was finding that so many lawyers had lost any passion for the practice of law if all they were doing was discovery, because they found it to be extremely kind of mundane, boring. And again, when I started practicing law, discovery was, looking through boxes of documents and putting, sticky, we called them stickies back then. We didn't even call them Post-its, right? But that's what we were doing, and filling out coding sheets and all that. And then, of course,
really exciting. It's exciting.
Right, really exciting. Made great friends, I will say that. Long-lasting friendships for sure.
Well, you're spending 9 hours a day sitting across from somebody. You got to have some conversation. I think.
You do. And so, as the tech really began to evolve, I started saying, okay, well, what's the law? Let's focus on the law, because I wasn't really in the tech yet. And so I was focused on developing lawyers, identifying specific lawyers on the team at the firm that I thought, you know what, this is a person who I think really appreciates the value of discovery, what its purpose is, gets excited about when you find the hot documents and you're getting ready for depositions or you're getting ready for summary judgment or trial. You see that excitement, and they want to be able to not only be the people who found that information, but they also want to be part of the team that deploys the information for purposes of developing the case. And so I had really, over a number of years, great lawyers who were learning. I was ahead in my learning and then teaching them. And sometimes they'd even, I think, hopscotch right over me. But still, then there was this tech side. And historically, the firm had somebody in a litigation support role, like a litigation support director. And that person, for the most part, was really managing the relationships with the outside providers. And we were suddenly looking to put somebody else in that seat. And Paul McVoy walked into my life, and we hired him really for that role. And then very quickly, Paul demonstrated almost overnight that he was so much smarter and so much bolder in his thinking than simply serving as a conduit. And no, disparagement for somebody who is playing that role. It's a critical role for sure. But Paul had this vision of building the technology within the law firm setting in a plaintiff's firm setting, which was very unusual,
Sure.
So that we could really capitalize on the cost savings and then also what we could do with what we were finding, right? So especially in a plaintiff setting, usually the economic model is a contingent law practice. You're only getting paid if you win. You're only going to have your expenses reimbursed if you win. If you bring a class action or some other traditional, mass tort or personal injury case, more often than not, the lawyers that are representing you are advancing the costs, the out-of-pocket costs, and also are not getting paid their legal fees until such time as they either settle successfully or win a trial and win all the way through the appeals that are likely to follow.
Sure.
So Paul saw this as, oh my gosh, why do we want to have monies going out of the firm to service providers when ultimately the output that we're going to get is going to be brought back to the lawyers to still have to figure it out. What are we going to do with that data? And so he brought in a tool. We really learned up on that tool. He was very familiar with the tool already. And we really had so many people understanding what we were building, and that was exciting. And it became its own enterprise within the firm. And then to Paul's credit, he said, you know, I bet you that there are other firms out there that would like to work with us, even though they don't want us to be in their lane, taking their cases, taking credit, but rather if we can be a strategic alliance, if they can come to us rather than go to another service provider over time, that will inure to the development of business relationships for the future, not just discovery, but case building, you know, having nice relationships out in the market. So we did that. We had firms that were traditionally our competitors and sometimes our strategic partners bringing their cases to us exclusively for discovery. And then we started promoting to people who weren't even doing the kinds of work that we were doing at all in terms of the substantive law area. Again, Paul's vision with a lot of, we're very collaborative. We really do enjoy spending time together and thinking big thoughts and what can we do next. And then it came to a point where Paul said, you know, I think we're being stymied. I don't think we're having as much of the opportunity that we should have because we are under this known firm brand.
Sure.
And now, while there are some people who were coming to us, there are some people who will never come to us. And so he wanted to push it out. I definitely was not a promoter of that idea or even a supporter of that idea initially, he would tell you, or he probably wouldn't, because Paul is just so humble and kind. He'd probably just say, forget about it, you know, whatever. But honestly, you know, he did have to push a couple of times. And it really came down to that if we weren't going to do it together, he was going to leave and go do it somewhere, somehow. And I just couldn't imagine not working with Paul.
Sure.
He is a phenomenal partner. He is also a phenomenal man. And I think that's really important, you know, to know people who are just really good people and whom you enjoy working with and you enjoy learning about, you know, who they are, what makes them happy, what makes them tick, what makes them sad, what causes them pain. Those kinds of relationships to me reach a level that is so different from some of the other relationships that we have day to day. And I just didn't want to lose it. And I knew in my heart that if he went and did it somewhere else without me, we'd always be friends, but we'd lose that, you know, everyday connection. And I just didn't want to do that.
Yeah, I mean that's really interesting too. And I guess one thing I'll comment on it. So you're telling me that on the plaintiff side, when you were working on the contingency fee, you couldn't find big box service providers that wanted to work on the contingency fee with you guys? That was difficult to do. No, but in all seriousness, I mean, it goes back to this notion of this, I think, change somewhat in the marketplace. And it's happening at a really bizarre time where COVID forced a lot of folks to work remotely, but also forced a lot of people to work under somewhat harsher conditions. Maybe more was being extracted from them. And so I think a lot of people really had somewhat of an existential crisis about career versus a job versus their life, the work-life balance. And I think a lot of people use this time to really take that leap and try to create more fulfilling environments in terms of the workplace. And I think that's one of the things that, again, I admire about you is that when I look at you, you're somebody who's really made it almost a lifestyle, and talking about your relationship with Paul and really wanting to work with essentially people that you obviously respect and hold in high regard, but essentially are your friends, if not extended family, if you will. Coming from a service provider that was family owned, I had that in many regards, and there's pros and cons with that. But I think that one of the things that I really like about this industry, even outside of my own company, it really does feel like an extension of who I am as a person. And that kind of adopting it into a lifestyle, I think, has been the reason why you find so many folks that not only are in this business for decades, but also, like you said, like people come to this business from so many different avenues, whether the entertainment business or the food business, or they're engineers or technologists, entrepreneurs or lawyers. And I think it's a testament to just how dynamic and how nascent and how ever changing the e-discovery world is. So it's really
I agree with you. I mean, I think about the many friendships I've established over these last 20 plus, nearly 30 years of practice. And the majority of the long-term relationships where I'm in touch with people, right, is in the e-discovery arena. I mean, of course, I have wonderful people at my firm, and I have wonderful people that I've done cases with at other firms and clients. But the e-discovery world is a really interesting universe. So, whether you're going to conferences, or because suddenly you're on opposite sides of somebody that you knew exclusively from the conference world, you were speaking and that person was speaking, maybe you were on the same panel, or maybe you were at a think tank like the Sedona conference, and people were popping up and sharing their comments or contributing to a paper that was in public comment, or even draft form for the working group itself. And then you would see that person or those persons again somewhere else. And I think we'll talk about this separately, but we just came away from Georgetown's Advanced eDiscovery Institute, which just had its program last week, middle of November 2021, in person, scaled down, of course, because of restrictions. I have to tell you, it was like seeing long lost family, right? Walking, like coming down the escalator at the hotel, which falls into the bar, and just wanting to hug everybody. And you're sitting there saying, well, can I hug you? I don't know if I can hug you. That like weird, awkward thing. And then most people saying, yes, yes. Like, you're just so desperate for that human connection.
It's like I imagine those, like, you see those family reuniting photos or videos on YouTube. I'm a sucker for those things. I can imagine seeing people at Georgetown just running to each other.
Yes. And the other thing too is when you're in the conference setting, for sure, in the e-discovery arena, yes, people are they're carrying their briefcases. I'm meaning, in their heads. But when you're there socially, you're having a cocktail, or you're having a meal, or it's a break and you're having coffee, everybody sets their briefcases aside, meaning they're putting their office or what they do or who they represent aside. And it really is, how are you? Having people say to me, oh my gosh, last time I saw you, Ariana, your kids were such and such and such age. They must be in their mid-20s and early 20s. Like, for people to remember that, right? That human element. And I think that's one of the things that has been a real, a very significant component as to why I stayed so committed to this space, because there's a human component that has nothing to do with the technology whatsoever,
right?
Or the law, for that matter.
No, I mean, and you know what, Ariana, I really appreciate the way that this is developing, because for those of you out there in e-discovery land, obviously there's been a kind of a timestamp. We try and keep these podcasts evergreen so they're always relevant. Now, kind of we're in November. Actually, Thanksgiving is Thursday. So I like the way this is developing into kind of a Thanksgiving themed discussion that we're having, but I digress. I wish I could have been in Georgetown, but it's exciting to see a reinvigorated desire to have these in-person conferences. I was worried for a while that people would become really comfortable with the completely remote conferences because they seemed, at least in the short term, to encourage more participation. So you saw like larger groups of people. I think that might have
Right.
been a function of just the fact that it was easier to attend them because people were home and a lot of them were free. But I'm very happy that these are kicking back up. And there's one in particular that we'll talk about, the Sedona Cooperation Workshop, that we're going to speak about in a little bit. But one last thing that I wanted to get out there in terms of your CV, because it's also extremely impressive, is that so all this stuff that you do, all these different things, whether it's the technology, the law, the advisory, the teaching, you also found time to become personally appointed by Chief Justice Roberts to the Federal Civil Rules Advisory Committee. So that's pretty cool as well.
Yeah, that I would say that is definitely a top highlight of my career. And I can't say that I personally made that happen at all. Quite the
Well,
contrary.
obviously,
Quite the contrary.
I think you did something. I think you might have done something.
Well, I do look, I mean, you know this, I really do encourage lawyers and law students for that matter to, and you don't have to be a lawyer, you could just be a human being, a layperson, but to follow what the rules committees are doing, right? There are different committees for the various rules, and I sit on the Federal Civil Rules Advisory Committee. For just kind of watching the process is really quite fascinating. It's not like a group of people come up with an amendment and there it is. There's a whole process. Any particular concept that the committee is even looking at has to go through sort of this, birthing, development, further evolution. There's a public comment period, which includes written comments as well as testimony. And for me, I spent quite a number of years really starting just before the 2006 discovery amendments. That piqued my interest. A senior lawyer had said to me, "Are you watching this?" And I was not really familiar with anything about the rules committee, and suddenly learned that you could comment. And I learned up and I did my research and I put in a comment. And from then on, I was hooked that I started attending pretty much every civil rules advisory and every standing committee meeting that I could. I would, travel and go, and I would read the materials in advance. And one of the things that's really quite gracious, and I think that this too has been part of an evolution, is the committee over the years, which of course there's turnover. It's not a lifetime appointment. You get a 3-year term, and then sometimes you're asked to, most of the time, I think you're asked to serve again. I'm currently in my second service. So new 3 years. And it's really a place where the committee encourages people who are in attendance, if they have a question, to ask it, or if they have a comment, to ask it. Now, obviously, the last 2 years with COVID have made that challenging, because if you're doing a meeting by Zoom, really the participants are not able to actively participate. They can listen, but they're not able to actively participate. I'm looking forward to seeing all of these great colleagues on the committee in person. We've not been in person for some time. So it's, that's another part of missing out. But I do encourage everybody who cares about the topic, and if it's discovery, doesn't matter if you're a lawyer, you're a technologist, you're a business owner in the space, you should be keeping an eye on what's happening, because it is really fascinating, and you do have an opportunity to actively contribute if you'd like.
It's actually interesting. So I don't know if you knew this, but you said that maybe you didn't make that happen, the appointment, but because originally Chief Justice reached out to me, and I was like, what, I just don't have the time to do this, but I do know this amazing attorney you should probably consider, Ariana Tadler. So I'm not going to take full credit for that.
I'll be sure to mention that to the Chief Justice when I see him next.
Please don't. I have a SWAT team outside my house. But let's pivot to